Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review.
I must admit, I struggled to find an immigration topic to discuss at the top of this week's episode. It seems, to me anyway, that everyone's kind of catching their breath following the conclusion of the momentous term at the Supreme Court and trying to figure out what's next. Plus, it was a holiday week, so the news was a bit quiet for good reason. So I went hunting and typed immigration news into Google. Here's something, quote, "A Texas state judge hammered the office of Texas Attorney General Ken Paxton for outrageous and intolerable conduct in investigating a Texas nonprofit that provides meals and beds to migrants in El Paso," end quote. Specifically, the Catholic charity Annunciation House Incorporated that Attorney General Paxton was trying to investigate and litigate out of business. Seems like the fiasco may be over, or at least significantly set back for Mr. Paxton's goals. And if you're understandably wondering whether humane immigration issues can still play a role in winning Democratic elections, look no further than the landslide victory for the Labour Party in the United Kingdom this week, wherein voter opposition to the Conservative government's Rwanda scheme of sending many asylum seekers to Rwanda played a role in Labour's first victory in 14 years and the worst Tory loss since the party's founding in 1830. All with the caveat, of course, that I am not an expert on the politics of His Majesty's government. The circuits were not quiet. I've got 6 cases to discuss with you. And you're not going to believe my unique take that I totally never say at the top of the episode about this, but here it is. They're interesting. The Supreme Court term has finally concluded, and so we're back to our regularly scheduled programming. First up is Gutierrez v. Garland, published by the Ninth Circuit on July 2nd, 2024. This case is about carjacking and many other things. To begin, quote, "The history of this case is unusually complicated," end quote. Can't wait! Mr. Gutierrez is from El Salvador and came to the United States in 1986 at 3 or 4 years old. He became a lawful permanent resident shortly after that, but as so often happens in these tragic cases, never naturalized. So when, 20 years later, he got involved in criminal activity and was convicted of carjacking under Cal Penal Code Section 215A, it wasn't simply prison that he was facing. His whole life as he knew it was put at risk. DHS initiated removal proceedings, alleging that the conviction was an aggravated felony crime of violence under INA Section 101A43F. Seems that after an immigration judge sustained the charge, the Ninth Circuit specifically held that this conviction isn't an aggravated felony in Solorio Ruiz v. Sessions in 2018. That decision apparently is no longer good law, though, but it was back then, so DHS amended the NTA to allege that the conviction is a theft-type aggravated felony at INA Section 101A43G, and alternatively that Mr. Gutierrez is removable for having been convicted of 2 or more crimes involving moral turpitude. Because Mr. Gutierrez also had a Cal Penal Code Section 44A petty theft conviction. But DHS didn't submit proof of the petty theft conviction, apparently, so the IJ didn't sustain that allegation. But then the law changed again, and then the IJ again sustained the crime of violence aggravated felony charge and the 2 CIMT charge because more evidence of the petty theft conviction was, I guess, submitted. By the way, and even though the IJ never reached the issue apparently, Section 215 carjacking is not a theft-type aggravated felony, at least not categorically so. That's United States v. Orozco, published earlier this year on episode 203. The IJ denied asylum and related relief, and the BIA dismissed the appeal without reaching the CIMT issue. New counsel, however, which appears to be the American Bar Association Immigration Justice Project in San Diego, filed a motion to reopen, challenging all bases for removal. The BIA denied it, and now it's before the Ninth Circuit, which remanded. Of course it did, right? We're starting off with the case. First, and despite all the bouncing around of legal precedent, carjacking violation of Cal Penal Code Section 215A is not an aggravated felony crime of violence, conclusively explained the court. Solorio Ruiz is no longer good law because in Stokeling, the Supreme Court changed up a bit the force required of the crime of violence definition. It lessened it. Now, quote, violent force means force sufficient to overcome a victim's resistance, however slight that resistance might be, end quote. Restated, quote, the altercation need not cause pain or injury or even be prolonged. It is the physical contest between the criminal and the victim that is itself capable of causing physical pain or injury, end quote, that matters. And yet still, explained the Ninth Circuit, and despite Solorio Ruiz no longer being good law, California carjacking does not meet that lessened force definition. The California statute permits conviction where the jacking of said car is, quote, accomplished by means of force or fear, end quote. That's an either or, and fear is not necessarily force. What's more, the Ninth Circuit said in Borden 4 years ago that the fear or force thing is not divisible. Jurors need not agree on the means of the carjacking. The plain language of the statute, which again requires the use of force or fear, resolves the issue of crime of violence to the court. Nevertheless, the Ninth Circuit buttressed its holding and discussed the California case law cited by Mr. Gutierrez, where in fact fear alone was used with no force at all to accomplish a carjacking. And this, despite the fact that Mr. Gutierrez's, quote, own case does not help his argument. His actions were unquestionably violent. He put a knife to the driver's neck in order to take the car which he was convicted of carjacking, end quote. But the categorical approach does not care. Although this alone, and really the text alone, resolves the dispute, the Ninth Circuit also explained that California carjacking lacks the required mens rea to be a crime of violence. Remember, after Borden, crimes that can be committed recklessly aren't crimes of violence. And well, wouldn't you know it, California carjacking can be committed recklessly. Actually, the holding seems even better for non-citizens than that because, quote, there is no mens rea requirement as to the force or fear element. Section 215 is overbroad on its face. Section 215 potentially prescribes reckless use of force or fear, end quote. While the statute does require that a defendant intend to deprive the victim of the car, that intent doesn't extend into how they do it, an intent to cause fear, much less an intent to use force. And to me then, it seems that the Ninth Circuit is saying that when a criminal statute is silent as to the mens rea that can be used to convict, that statute won't be able to meet the new Borden crime of violence requirement of purposeful or knowing. And well, that's a big holding. If that's what they're saying. Counsel pointed to analogous criminal statutes, and the Ninth Circuit discussed them to show that this is indeed how crimes work in California. Like robbery. So Cal Penal Code Section 211 robbery is not a crime of violence after Borden?
Seems like that's strongly implied in this decision here, prior precedent notwithstanding. Like, really, really strongly. Anyway, carjacking isn't a crime of violence. But petty theft is a CIMT, I believe, one of the odd quirks of crimmigration. So if California carjacking, undeniably a worse crime than petty theft, is also a CIMT, then Mr. Gutierrez is removable. But that will also likely come down in part to mental state, and the Ninth Circuit sent it back to the BIA, as the BIA never actually addressed the issue. I'm sure Mr. Gutierrez has some good arguments, though. Before sending it back, the Ninth Circuit did summarily affirm the IJ on a lot of things, like the adverse credibility finding. The Ninth Circuit also affirmed the denial of a 212H waiver as a matter of discretion and denial of Convention Against Torture Protection, all things that are only important if Mr. Gutierrez is removable in the first place. The Ninth Circuit also affirmed denial of reopening for submission of a psychological report and Mr. Gutierrez's ineffective assistance of counsel claim against prior counsel. Again, mostly stuff that would only be relevant if the BIA deems the conviction a CIMT. And it does seem that current counsel left no stone unturned on appeal. But anyway, it's an important crimmigration win, and now everything seems to come down to the quintessentially ambiguous CIMT definition on remand. A definition to which, by the way, that the Ninth Circuit no longer owes the BIA any deference. And it means congratulations Harper Ataqua and Olavo Michel of the very important ABA Immigration Justice Project San Diego, California, for petitioner. And another interesting thing caught my eye. The BIA held that the IJ didn't err in sua sponte reopening to consider new charges, or that is to say the Ninth Circuit couldn't review such a discretionary thing as sua sponte reopening mid-case. For that reason, the Ninth Circuit also held that Mr. Gutierrez's res judicata arguments were misplaced. But that's only because by reopening the case, the same initial removal proceedings were ongoing. Don't forget that in the Ninth Circuit and in other circuits, quote, res judicata bars DHS from initiating a second deportation case on the basis of a charge that it could have brought in the first case where the first NTA was the subject of a final judgment on the merits, end quote. In the Ninth Circuit, that's Al-Mutarib v. Holder from 2009. And that is Gutierrez v. Garland. Next up is Cruz Galicia v. Garland, published by the First Circuit on July 1st, 2024. This case is about asylum. The petitioners are a family from Guatemala, with the father, Mr. Cruz, the lead applicant. And boy, oh boy, I read an article about this about a decade ago in Foreign Policy magazine, but I've never actually seen one. Mr. Cruz and his family alleged that they had suffered and feared persecution in Guatemala as members of the particular social group, quote, climate refugees, end quote. Not gonna lie, there's probably a better way to define that group because inclusion of the word refugee in your particular social group probably is a legal term that implies the very thing that Mr. Cruz is trying to get, but you get the gist of the claim. Mr. Cruz claimed that the family had fled Guatemala because, quote, for the last 2 years, droughts, storms, and the COVID-19 pandemic had such a terrible effect on their ability to live and feed themselves, that he and his partner feared that their son might die of malnutrition and felt they had to leave in order to survive, end quote. They additionally pointed to news reports describing Guatemala's malnutrition crisis, and they asserted that they wouldn't be protected from starvation by the Guatemalan government. Among many things, the immigration judge didn't believe that the proposed particular social group of climate refugees was viable. The BIA affirmed without opinion. And the First Circuit affirmed that. It's true that the 2021 Department of State report states that the Guatemalan government, quote, recognizes internally displaced persons within its border displaced by climate change and natural disasters, end quote. But that, without more, is not sufficient to show that such people are socially distinct in Guatemala. That is, that climate refugees or people displaced because of climate issues, I suppose, are recognized as separate by Guatemalan society. As to malnutrition and the like, well, explain the First Circuit. It seems that large swaths of Guatemala suffer similar issues. So again, not socially distinct. Or particular, I guess. This is about the end of the analysis in this case, which is a shame given the importance and the uniqueness of the legal claim presented. That's kind of what Mr. Cruz argued too. He argued that the BIA erred in failing to give his unique argument analysis by a 3-member panel. And true, a unique legal issue like this might qualify for 3-member panel review before the BIA under the regulations. But on the other hand, under the regulations, the BIA, quote, must summarily affirm an IJ's decision, end quote, where certain factors are present, like it's correct or squarely controlled by BIA precedent. The First Circuit saw that at play here, as the particular social group proffered by Mr. Cruz was clearly deficient on social distinction under BIA case law to the First Circuit. All of it meant that the BIA was affirmed, and Mr. Cruz lost his case. But I look forward to seeing more cases with particular social groups like this, including even in the First Circuit, although perhaps replacing the term refugee with another term in the particular social group definition itself. Because after all, and I could be wrong, but after Loeb or Bright, the BIA's definition of what a particular social group is might no longer be the governing definition in every circuit, or at least it's subject to challenge. And that is Cruz Galicia v. Garland. Sticking with the First Circuit, we have Williams v. Garland, published by the First on July 2nd, 2024. This case is about former INA Section 212C, relief. Mr. Williams is from Jamaica, and he's been living as a lawful permanent resident since 1985, when he was 19 years old. He too didn't naturalize, like our decision at the top of the episode, although he didn't have much time to do it. 4. After he was married in 1989, quote, he had sexual intercourse with his 12-year-old niece, end quote, in 1991, and he pled guilty in 1993 to 2 counts of first-degree sexual assault and 2 counts of risk of injury to a minor in relation to that conduct. Still remained married, though, until 2000. They eventually separated, and he eventually married somebody else. Before he did, he spent 9 months in jail, only 9 months, and was released as a sex offender. But DHS figured it all out 27 years later in 2020 because immigration never forgets and initiated removal proceedings. Mr. Williams conceded removability, but because the conviction was so old, he applied for a former INA Section 212C waiver, something that hasn't existed since 1997. But it often exists for old crimes depending on the circumstances, and everyone agrees that it applies here and could have let Mr. Williams keep his green card, if granted. No hardship or anything required either of a 212C waiver. Just really a discretionary waiver, a second chance. In deciding, the immigration judge here weighed the positive and the negative factors under matter of merit and granted the waiver. Some of those positive factors included Mr. Williams' 28 years of no encounters with law enforcement, his remarriage to a U.S. citizen, and their raising of a daughter together, in addition to Mr. Williams' sobriety since 2013. But DHS appealed, and the BIA reversed the IJ by split decision. Honestly, the BIA just didn't like that 1993 conviction and was not willing to forgive. Mr. Williams petitioned for review. And the First Circuit affirmed the split BIA. And heck, the First Circuit isn't even quite sure whether it has jurisdiction to review this. And rightfully so. It's complicated. But the First Circuit just skipped to the merits, which it sometimes does when it intends to just affirm the BIA, and so avoid the whole jurisdictional analysis and setting the jurisdictional line for all future cases. Even so, though, Mr. Williams can't just argue that the BIA improperly weighed evidence in its discretionary analysis. He needs to bring some sort of legal claim or mixed question. Here he argued that the BIA failed to appropriately consider Mr. Williams' wife's testimony, and also that the BIA didn't follow how it usually decides these types of cases. The First Circuit rejected both arguments. The court believes that the BIA did consider the wife's testimony, even describing the, quote, significant equities, end quote, that Mr. Williams' case presented, and the BIA cited the portion of the transcript where the wife testified. Simply put, the BIA did enough, even if they didn't write as detailed a decision as the IJ did in granting relief. It is true in the First Circuit that, quote, when the BIA announces and follows, by rule or by settled course of adjudication, a general policy by which it exercises discretion, an irrational departure from that policy can constitute action that must be overturned under the APA, end quote. That's Thompson v. Barr, all the way back in episode 4. In layman's terms, the BIA can't adjudicate a claim for relief or something else in a way or using a framework that's totally different than how they usually adjudicate things. In his attempt to make that showing in regards to 212C relief, Mr. Williams submitted no less than 76 unpublished BIA decisions granting 212C relief. Ben Winograd earning his commission. Quote, from this survey, he argues that the BIA has a settled course of adjudication that grants Section 212C waivers in cases where a non-citizen has a single conviction that is over 25 years old, end quote. Counsel really doing all they can here. But it fell short to the court. The First Circuit saw Mr. Williams' conviction as different, undoubtedly, than all those other cases. The court couldn't say that the BIA acted irrationally or departed from a settled course of adjudicating Section 212C waivers when the analysis of a waiver is so fact-intensive and depends on the conviction, it seems. End quote. For example, of the cases that he offers where the BIA granted relief, only 4 involved crimes against minors, end quote, and none of those involved sexual intercourse with a minor family member. And so, in fact, the First Circuit's own research indicates that the BIA has repeatedly denied waivers for crimes with circumstances similar to Mr. Williams's. All of it means that Mr. Williams lost his case and risks removal after many years in the United States. And that is Williams v. Garland. Moving on to a short one from the Second Circuit, Garcia Carrera v. Garland, published by the Second Circuit on July 3rd, 2024. This case is about cancellation of removal, litigated by the non-citizen pro se, no less. Mr. Garcia Carrera is from Mexico. He's been here for a long time, and when placed in removal proceedings, applied for non-LPR cancellation of removal, claiming that his removal would cause exceptional and extremely unusual hardship to his daughter. The immigration judge and the BIA disagreed. Just the normal hardship from family separation, reasoned the agency. On petition for review, the Second Circuit was set to just dismiss the whole thing as non-reviewable, but then the Supreme Court published Wilkinson. Now, circuits can review mixed questions of law and fact like this, specifically as well in the non-LPR cancellation hardship context, as was at issue in Wilkinson, at least when the facts are not in dispute. That would include Mr. Garcia Carrera's pro se argument that the agency overlooked and mischaracterized evidence and didn't consider everything cumulatively. Smart arguments, and arguments to remember when trying to bring your cancellation hardship claim at the circuit after Wilkinson. Problem is that the Second Circuit doesn't read the record the same way as Mr. Garcia Carrera. Really, and discussed very quickly by the court, the Second Circuit believes that the IJ and the BIA adequately considered everything cumulatively and applied the well-worn exceptional and extremely unusual hardship legal standard. It does not believe that the agency mischaracterized or blatantly ignored evidence. And so it ruled against Mr. Garcia Carrera. It's a very short decision, but hey, at least the Second Circuit reviewed it and provided a bit of a roadmap for bringing such claims in the future post-Wilkinson. And that is Garcia Carrera v. Garland. Say goodbye to missed calls and wasted time on unqualified consultations. With Staffy Live, you get a dedicated team of truly bilingual and highly empathetic specialists answering the phones for your immigration law firm 24/7. Staffy Live specialists go beyond just answering calls. They qualify callers by asking the right questions, ensuring that only qualified consultations make it into your calendar. Plus, they don't stop there. Staffy Live can also handle follow-ups, so you can focus on what you do best, practicing law. Staffy Live is a service for immigration law firms only. And here's the best part. You can try Staffy Live absolutely free for 15 days, no strings attached. Just visit www.staffy.cc, that's stafi.cc, and click Get Started. Of course, use the code FREE to claim your free trial, or click on the links in the show notes.
Moving on to Rivera et al. V. Garland, published by the 8th Circuit on July 5th, 2024. This case is about asylum, and it's an exciting one from the 8th Circuit. Mr. Rivera is the lead petitioner. The others are his family members. Mr. Rivera was a pastor of a Christian church in El Salvador. He and others regularly tried to preach and evangelize to gang members. Many gang leaders told him to stop, and the gang started monitoring who attended his services. Because, naturally, a godly life is not very consistent with MS-13 activities. Mr. Rivera was successful with at least one MS-13 member, Ronald Granadino. The gang really didn't care about Mr. Rivera and Ronald's relationship until Ronald left the gang and joined Mr. Rivera's church. At that point, the gang told Ronald that he needed to leave town. He didn't, and things quickly got horrible. Mr. Rivera, his daughter, Ronald, and others were jumped by the gang as they left church one day. The gang threatened to kill them all and said no one messes with them. Ronald belonged to them, not Christ, the gang said. They put Mr. Rivera on the ground, put a gun to his head, and pulled the trigger, but the gun didn't fire. Then they executed Ronald, who was lying face down next to Mr. Rivera. When the gang left, Mr. Rivera and the other survivors called police, who told Mr. Rivera that he needed to leave town with his family. He stayed for a while and even went back to preaching, but soon thereafter, it seems, fled with his family to the United States, as did the others who were present, eventually. An immigration judge found Mr. Rivera and the other family member witnesses who testified in consolidated proceedings credible. And yet, as you can probably guess by now, the IJ didn't see a nexus to a protected ground. The IJ held that this was simply criminal gang activity and the gang being upset about Ronald leaving, not a fear of death for one of the 5 protected grounds like religion. Now, I wrote what I just said before actually reading the paragraph in the case, but it turned out to be completely accurate. Gun to the head of the preacher with the trigger pulled as he kneeled in front of the church and with the former gang member turned religious Christian lying face down dead next to him. The BIA affirmed. The 8th Circuit remanded. It's not in dispute that, if it happened for the right central reason, the harm would be bad enough to equate to past persecution. So yes, this case is all about nexus. And again, as in all circuits, religion can be one central reason for harm, even if there were multiple reasons. The agency erred here, quote, both the BIA and the IJ treated the conclusion that one central reason for Mr. Rivera's persecution was the gang's anger about Ronald leaving the gang as proof that Mr. Rivera's religion was not one central reason for the persecution. Neither the BIA nor the IJ considered the possibility that Mr. Rivera's religion could have been an additional central reason for his persecution. This was error, end quote. Explained the 8th Circuit, and as in the very non-citizen-friendly Chicas-Machado v. Garland decision from the 4th Circuit on very similar issues, episode 168, even if the ultimate, quote, trigger, end quote, for the gang to harm might have been Ronald leaving the gang, quote, this does not disprove the possibility that religion was an underlying central reason for the attack, end quote. The BIA and IJ's analysis was a, quote, oversimplification of the nexus analysis, end quote, that failed to account for Mr. Rivera's role in evangelizing Ronald, and it cannot stand. Plus, explained the court, the IJ and the BIA relied on unsupported facts and ignored relevant evidence and testimony that sure seems to show that religion was one central motivating reason. Heck, Mr. Rivera was told to stop preaching and threatened with death if he didn't. Really, lots of stuff ignored by the IJ and the BIA, but discussed by the 8th Circuit, and that must be considered on remand. Sure seems like the 8th Circuit is sending it back for a grant. and with this pretty excellent standard for Eighth Circuit mixed motive cases moving forward. So listen up, quote, "Even if a protected ground was not the final trigger for persecution, persecution may, at least in some circumstances, be on account of religion, if it is the practice of an individual's religion which leads him to being targeted in the first instance." End quote. Remember that. So again, remanded. But the Eighth Circuit rejected Mr. Rivera's other arguments, and they were actually pretty complicated. The first other argument rejected was that it was improper for one of the BIA members on this panel, temporary board member Crosset, to be part of deciding the case in the first place, because he was improperly appointed. He was appointed a temporary BIA member in October 2022, which was his second appointment. And under the regulations, temporary BIA members can be appointed for 6-month terms. But the Eighth Circuit rejected this. That is, that temporary board members can't be temporary board members for more than 6 months. Explained the court, although the regulation for temporary IJs expressly says that they are renewable, and the regulation for temporary BIA members apparently does not, this silence does not mean that temporary BIA members can't have their temporary terms renewed just like temporary IJs. Explained the Eighth Circuit, attorneys general have broad authority to appoint BIA members and temporary BIA members regardless of what the regulation says or doesn't say. Now, we've seen an argument like that before, and it's been rejected by courts before. More interesting to me was actually a related argument about temporary BIA member Crosset, and it was actually the first one discussed by the Eighth Circuit. Mr. Rivera also argued that temporary BIA member Crosset was improperly appointed because, essentially, the regulation for appointment of temporary BIA members mentions EOIR's director and sometimes a deputy attorney general as the appointing official, but not actually the attorney general, at least when it comes to temporary BIA members. And here it seems that the actual Attorney General, Garland it seems, appointed temporary BIA member Crosset. The Eighth Circuit rejected this argument too, quote, "The Attorney General has authority over issues of immigration, and he has the power to delegate that authority to inferior officers," end quote. That he delegated that power by regulation to EOIR's director does not mean that the Attorney General himself can't still do it when he or she wants to. While all of that sounds a bit obvious to me, it isn't so obvious given the Supreme Court's decision of Attorney General authority and immigration delegation in United States ex Ralicardi v. Shaughnessy, a 1954 decision. The Eighth Circuit distinguished that Supreme Court case, but that seems to be where all of this argument begins, so read up on that case if you seek to make a similar argument in other circuits going forward. The Eighth Circuit concludes by explaining that it did not see error in the IJ or the BIA's analysis of future persecution either for Mr. Rivera or some of the family members, but that again it is sending it back for past persecution analysis as to Mr. Rivera. And if he succeeds there, he'll have a presumptively well-founded fear of future persecution, and his derivative family members will be able to benefit. Pretty big case in the Eighth Circuit on an issue that is mixed motive nexus. That's not often favorable in the Eighth Circuit. And that is Rivera et al. V. Garland. We conclude with Hatchett v. Andrade et al., published by the Eighth Circuit on July 3rd, 2024. This case is about adjustment of status and jurisdiction. One of those, gosh darn Patel. If you're not here for the complicated jurisdictional argument, I'll see you next week. But if you remained, Mr. Hatchett is from Sierra Leone. He was paroled into the United States and applied for asylum but was denied. Unsure what happened, and it seems like there's a bit more, but in 2015, he married a Miss Physi, who is a U.S. citizen and who filed an I-130 petition for him. Mr. Hatchett then filed a Form I-485 adjustment of status application to become a lawful permanent resident. But, quote, USCIS found that Mr. Hatchett was inadmissible because he had falsely claimed United States citizenship when seeking asylum in 2002, end quote. That makes absolutely no sense, right? But I'm sure there's more to it. Seems like USCIS approved the I-130 but denied the I-485 multiple times, so Mr. Hatchett sued in federal district court.
Then USCIS reopened the application for adjustment and denied for another reason. This time, USCIS found that Mr. Hatchett was statutory ineligible due to, quote, prior misrepresentations about 1, his children, during an application Mr. Hatchett made while in a prior marriage, which would have led to the discovery of the fact that Mr. Hatchett was in an adulterous relationship, and 2, his citizenship status, which USCIS previously cited, end quote. And in any event, USCIS apparently determined that Mr. Hatchett didn't warrant adjustment of status as a matter of discretion. I would think that that final conclusion alone would tank the case for district court review, but that's not actually what the 8th Circuit held. The 8th Circuit held worse. Anyway, Mr. Hatchett amended his Federal Administrative Procedures Act complaint, but the district court dismissed for lack of subject matter jurisdiction, for, by that point, the Supreme Court had issued Patel. And the 8th Circuit affirmed that dismissal. Let's get back into it. It's been a couple of months. INA Section 242A2B reads, in pertinent part, that except for at Section 242A2D, federal courts lack jurisdiction to review, quote, any judgment regarding the granting of relief under, end quote, 5 statutes, which include the adjustment of status statute. Subparagraph D in turn, the Savings Clause, permits review of constitutional claims and questions of law, but only if brought on petition for review. And you don't bring petitions for review in district court. You only bring them to the circuit after going through the agency. So that's the statute. Then 2 years ago in Patel, or was it 3? I can't even remember anymore. The Supreme Court said, among other things, that even in removal proceedings, the phrase, quote, any judgment regarding the granting of relief under, end quote, means that federal courts are without jurisdiction to review both discretionary and non-discretionary judgments related to the granting of relief, including factual findings, at least when they're in dispute. And that includes whether certain things actually occurred that would make a non-citizen inadmissible, even though inadmissibility has nothing to do with discretion. So in Patel, Mr. Patel wanted to adjust status, which is a listed thing at 242A2B, but he was found inadmissible because it was believed that he made a false claim to U.S. citizenship. If he didn't, he's not inadmissible and he can adjust, and that's not a discretionary finding. But still, the Supreme Court said whether he was inadmissible for having made a false claim to citizenship could not be reviewed because it was all tethered to adjustment of status, which is one of the statutes listed at 242A2B. Far be it from me to relitigate Patel on this podcast. That's not something I do. And that's all if you can even get to federal circuit court anyway through the petition for review process, as occurred in Patel. Taken then all together with the statutes I just read and the Savings Clause, and as Justice Barrett recognized briefly in Patel, it would seem that non-citizens might have no recourse to get any judicial review over USCIS adjustment of status denials, even if questions of law or constitutional claims are presented, unless USCIS decides to put the non-citizen in removal proceedings, the non-citizen loses, the BIA affirms the loss, and then the non-citizen petitions for review. Because the Savings Clause that permits review of these things only applies on petition for review. And that includes, because of Patel, first step inadmissibility determinations, now covered under Section 242A2B, because of Patel. Again, constitutional or legal claims could be reviewed because of Section A2D, the Savings Clause, but that only applies to petitions for review that require entire removal proceedings through the BIA to become available. What a wild and arbitrary administrative framework for Congress to impose, but that's what Justice Barrett and the majority all but condoned in Patel 25 years after Congress actually wrote the statute. Because, as the Patel majority notes briefly in dicta, quote, foreclosing judicial review unless and until removal proceedings are initiated would be consistent with Congress's choice to reduce procedural protections in the context of discretionary relief, end quote. Again, though, even if the issue is a totally non-discretionary one, like, say, to use an extreme example, denying adjustment of status because the USCIS adjudicator mistakenly believes that homosexuality is a ground of inadmissibility. Or less extreme, What if USCIS were to deny adjustment of status based on a completely incorrect belief that the non-citizen was an MS-13 member, even though there was no evidence and the non-citizen in fact had never been a member or even been affiliated, but did have a tattoo similar to one? There would still be no district court review ever, it would seem, Patel would imply, unless USCIS began removal proceedings and the non-citizen went all through removal proceedings to go to petition for review. And that is essentially what the Eighth Circuit held here. Really, Mr. Hatchett was largely relitigating Patel to the Eighth Circuit, but the court rejected those arguments and found that the logic of Patel destroyed an adjustment of status challenge, at least when based on factual disputes. Again, even though it's in the inadmissibility and not discretion context, quote, all 9 justices effectively recognized that judicial review of fact findings would be foreclosed in the exact scenario presented by Mr. Hatchett's case, end quote. And that's true, although Justice Gorsuch and the dissent were trying to make a point and explain why they dissented. Citing to the D.C. Circuit, 7th, 5th, 4th, and of course 11th Circuits, the 8th Circuit concludes by stating that, quote, every circuit court to have considered this issue post-Patel has held that Section 242A2BI precludes, at a minimum, judicial review of fact findings related to discretionary relief decisions made outside of the removal context, end quote. Remember, Patel wasn't about district court review, but the logic and the dicta strongly supports foreclosing such review for cases like this, said the Eighth Circuit. The Eighth Circuit also rejected Mr. Hatchett's argument, adopted by at least one district court, if I'm not mistaken, that Section 242A2BI, quote, does not apply outside the removal context, end quote. That's based on some of the language in that statute, and there's no real analysis used by the Eighth Circuit to reject the argument, so keep making the argument in other circuits. Okay, what about the, quote, presumption of reviewability under the APA and the requirement that Congress speak clearly when it wishes to overcome such presumption or take away judicial review, end quote. Something from Santos Zachariah, for example. And something very in line with everything the Chief Justice was saying in Loper Bright, no? Well, explained the Eighth Circuit, Section 242A2BI is clear about its jurisdictional scope, so the presumption is rebutted. And that's pretty much just Patel. Quote, at bottom, Mr. Hatchett, in his briefing, asks us to disagree with the Supreme Court, end quote. Brutal, but such is Patel. Here's a footnote to end the episode with. For all that Patel bad, the Eighth Circuit does throw a bone in a footnote based on its pre-Patel precedent, PPP. It seems that my homosexual inadmissibility hypothetical actually might be able to get district court review in the Eighth Circuit and maybe even elsewhere. Quote, what remains reviewable or not outside of the removal context is still an open question because Patel does not speak to anything beyond fact questions, end quote. So in that first hypothetical I gave earlier on in the case, there actually weren't factual questions at issue. That was a pure legal question, and so maybe, even though it's tied to adjustment of status, maybe you could get district court review. And remember it, but don't hold your breath. And in any event, the first step in admissibility question for adjustment of status will so often be fact-based. If the facts occurred as USCIS believes they did in a given case, the non-citizen is likely inadmissible. That's usually what the dispute is about. But check out footnote 1 in this decision, and the cases cited therein, when crafting your district court arguments going forward to try to get around Patel in the Eighth Circuit and elsewhere. We'll get a good precedential case on Patel soon, I'm sure of it. And that is Hatchett v. Andrade et al. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/immigration review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.